morning. May it please the court, my name is Joseph DeShiel. I'm a Special Assistant Public Defender for the 10th Circuit. I represent the appellant, Lewis Murray, present with his family today here in court. I do have a quick question. Whenever I've been here before, it's always been 15 minutes on a criminal case. So do I have 15 or 20?
It's 20.
Okay, thank you.
Unless you want to reserve some time for rebuttal.
Well, I do. I'm going to reserve.
So then it's 15 and whatever you reserve.
I'm going to reserve 3 minutes, please.
Okay, so.
This case is a criminal case that arises out of an incident at the Kmart store in Temple Terrace, Hillsborough County, involving Mr. Murray, a co-defendant, Shadabea Jones, and several witnesses, but primarily the alleged victim's store security guard, Warren Brittingham. There was an obtaining inside the store. There was a recovery outside the store. Exactly where is clearly the subject of what was disputed at the trial. There was, at some point in time in the incident, there was the use of force. Sometime after the arrest in this case, Mr. Brittingham was fired, and the appellee became aware of that and filed a motion in limine to exclude any discussion of the fact that he was fired. That matter was heard prior to the trial. The lower court ruled yes. The fact that he was fired will be able to be discussed. Pretty much everything else, we're going to just see how it goes. I don't want you to open a can of worms. That's what the lower court said. So we really have to look at the questions and answers in the actual examination of the witnesses.
Did the employee's personnel records indicate why he was fired?
Well, we really don't know because the subject of that was excluded.
Well, I'm just wondering why the records weren't introduced in the record as a court exhibit for a proffer, so that the court could determine exactly what the reason was for his termination, because there's a lot of argument about it, and it seems to me that the defense ultimately concedes that it was speculation that he was fired for this incident. And the defense agrees that he had a civil suit that was settled. So I'm trying to figure out, how was this court, the trial court, put on notice as to why, the real reason he was fired, so the court could make a ruling?
I think there was some deposition testimony that was given which put the parties on notice of what those issues were.
But was that introduced? I didn't see in the record any deposition testimony.
No, there were no depositions that were entered. There were no employee records that were entered, but my argument about the employee records is that that's going to be excluded according to the judge's ruling. You know, we're not going to open a can of worms. We're not going to get into a civil suit.
But the bottom line is, you wanted to tell the jury it's this employee's fault because he exceeded or he violated company policy when he walked out there and stopped the car.
Well, outside a certain perimeter outside, not exactly right outside the door, but there's...
Question. Let's say that he followed the defendant to the car and said, "Sir, I think we got a problem here. Come inside, let's talk about it." The defendant swung at him right there. Does that mean it's not robbery?
Well, but the point is, this was the inability of the Mr. Murray, the appellant, to be able to ask the question of Mr. Brittingham. It's not, I mean, that was going to be subject to some dispute either way, but the point was the whole...
Would the jury be instructed it is a legal defense for Mr. Murray if you find that Mr. Brittingham violated company policy? Is that a jury instruction?
That, and clearly this isn't an instruction case. The instruction would have been on abandonment. The instruction, well, it's the theory of the defense is that it was not in the course of the taking. And where the confrontation took place, and to a certain extent whether or not Mr. Brittingham would testify accurately as to that, was the subject of this issue. And even the appellee in their answer brief on page 2, their objection is, just to clarify, we would ask that the fact that he did not follow Kmart policies and procedure is irrelevant. That's clearly the whole issue of what was the basis for his firing was the issue. So then we move on to, there's a commencement of the trial, and prior to jury selection, we have a statement from the court that, and clearly this is all initiated by the trial judge, discussing what the plea offers are. And we don't know exactly how the state came to their plea offer of 30 years bin man, But what we have from the judge is, just say it, here I'm trying to avoid, if you lose the case, you're going to be in prison for 30 years. People try to find out ways of trying to say, I didn't understand this, or I don't understand that. I'm giving you a chance. And actually, going back to page, the judge basically says, you know, if you get found guilty, it's 30 years, but I have the discretion to sentence you up to life. That was not true. That was not accurate. At that point, the defendant is under the impression he has something to gain by going to trial.
Is this the first PBL?
It is a first PBL armed robbery, yes.
Then how is that an inaccurate statement?
Well, it's an inaccurate statement because there was a prison release reoffender notice filed, and if you're found guilty of a first
mandatory
PBL,
life.
it's mandatory life.
But the court, why couldn't we conclude that the court wanted to find out if he really wanted to go to trial? And he's making a free and voluntary decision to go to trial, and he's aware of what the state has offered. And he's freely and voluntarily rejecting that.
But
why can't you reach that conclusion?
No, because the court has taken it upon itself to give advice to the client. This is the consequence of you rejecting this plea and going to trial.
And you could get up to life.
Well, that's wrong. It's not that you could get up to life. You'll get life. There's no sentencing discretion, and of course, when we get to the sentencing transcript, there's no discussion at all that there's some ability to impose something less than life. It's automatic life.
Well, we also assume that his defense attorney is also advising him too, confidentially.
Yeah. The defense attorney doesn't enter into the picture.
There's no objection from the defense attorney that this statement by the court is inaccurate.
No, but I don't think that relieves the judge of the duty, once he entertains the subject, to advise the defendant correctly. Again, we talk about we get into the trial. There was clearly several attempts by the trial counsel for the defense to bring up the issue of the store policies, and they were all rebuffed. And the defendant was committed as charged and sentenced to a mandatory life prison. We've raised two issues. One is the limitation of cross-examination, which is pretty much spot on with the Peterson case from this court, which is discussed extensively by both parties in their briefs. The second case is a much more novel issue, which I've discussed in terms of due process under the Florida Constitution, the United States Constitution, and for no other term that I could come up with, the term would be judicial misadvice. If I could start with the limitation of cross-examination case. The Peterson case went on two issues. Again, the issue that was discussed, there was a reversal on both limitation of cross-examination and the denial of an instruction. The instruction was later the subject of some case law review, but Peterson itself was never overruled or modified based upon the peculiar facts of that case.
Well,
in fact, we can say
Peterson testified she wanted her job back with the same employer. Was there any evidence that Mr. Brittingham wanted his job back with Kmart?
Well, there was some discussion from the state that no, he didn't. Mr. Brittingham didn't. Of course, Mr. Brittingham wasn't really permitted to talk about that. If the judge had opened it up, we might know more. But again, when we tried to get into the reasons for the dismissal, the state objected, and of course they actually tried to go into the back door on one occasion. But I guess what I'm trying to say is, it wasn't a question of whether Mr. Brittingham wanted to get his job back. The issue is, what are the circumstances which would lead Mr. Brittingham to testify the way he's testifying, as well as bias and motive. We clearly get into that, but why he would testify against Mr. Murray the way he did, obviously he caused him to lose his job. But again, the issue is what issues bear upon the way Mr. Brittingham would present his testimony in court. And of course, we don't get much of that because the judge excluded all that from coming in. So, but in Peterson, we talk about, there was the limitation of cross-examination. They clearly said, no, that should have been wide open. It was an abuse of discretion. The fact that Mr. Brittingham, according to the prosecutor, didn't want his job back, I don't really think matters any, because it has to do with the circumstances of why he got fired. And he might just want to make himself look better, that he was a victim in his termination. But again, I think pretty much all of that has got to be considered fair game on cross-examination. He's the state's main witness.
But you were unable to demonstrate to the trial court that he got fired for this incident. So
well,
if it's speculation, why would the court allow speculative evidence?
Well, that's the whole reason why we should have been able to get into it. But
you had the records.
Well, I don't think that means it's not preserved, Your Honor.
But they're not in the records. We can't review that he was definitely fired for this incident. We can only speculate.
There was a timing issue, of course, that this occurred sometime after. And of course, the state tried to make it out at the end that, well, we don't really know that he was fired because of this. But if we had been able to ask Mr. Brittingham directly about that, we would have perhaps gotten the answer that the appellant should have been able to get.
Well, they took his deposition.
But the judge didn't. Well, of course, discovery depositions are wide-ranging. When you get into court, the judge is going to put the reins on whatever he feels is improper cross-examination. We're saying it was an abuse of discretion to deny inquiry into that subject of bias, motive, and why he would testify the way he would testify.
But neither defense counsel presented the deposition transcript to the court at any bench conference or any pretrial motion to show that that is indeed why he was terminated.
I don't think that amounts to a lack of preservation in this case. I mean, it goes to trial tactics maybe, but it doesn't go to a lack of preservation. The issue was raised by the appellee in their motion in limine. We don't want any of this coming in. The judge said, well, don't open up a can of worms. A little bit of dancing around, but when the question was asked, trying to link the termination to this case, there was one witness that says it was a big fiasco. They wasn't allowed to ask what the big fiasco meant. So I think the issue's preserved, and I think it's an abuse of discretion. Now, on the due process, judicial misadvice, we have a couple of cases from the United States Supreme Court. They're really not new law in the state of Florida. The state of Florida has been applying Strickland versus Washington in the context of pleas for quite a while. But the Lafler versus Cooper case is a very important comment that the judicial system is not now a system of trials, it's a system of pleas. And that's why they extended the ineffective assistance of counsel, what those two cases, Lafler and Missouri versus Fry, deal with what's the proper pleading for prejudice and deficient performance. So we have an emphasis now on what happens in the context of the plea bargaining process is subject to judicial review. And I like to describe it as the four hemispheres of this issue. You have two hemispheres where you have the defense attorney misadvice to enter a plea, defense attorney misadvice to reject the plea. Those are both covered under the law. You have the judge misadvice causing a waiver of rights and entry of a plea. That's clearly well-defined remedy in court. But the last hemisphere, the last quadrant, is what happens when the judge misadvises the defendant about specifically the judge's sentencing discretion, and there's a rejection of a plea, a beneficial plea.
Isn't it true that the only plea Mr. Murray would accept was 4 years? He said that.
That was in the record, yes, sir.
He said, I only want 4 years.
Well, no, I don't think he said, I only want 4 years. He's, in the context, the judge has already made the statement about what his sentencing discretion is. And the judge sort of persists in, and again, this is, well,
is there anything in the record to support the idea that if he knew that it was mandatory life versus discretionary life, that this would in any way, shape, or form change his decision? Are you saying that, oh, well, if it's mandatory, then I'll go ahead and accept the 30-year offer?
Well, no.
Isn't it kind of stretch things a bit?
And I think the United States Supreme Court talks about it's not a situation of there's a specific remedy. I liken it to if the trial court made the error, we're going to send the case back to the trial court to make them figure out how to make it right, okay? That's not the relief that I've asked for in this case. The primary relief that I've asked for was to just reduce the sentence to 30 years, but clearly under Lafler and the Missouri versus Fry case, there is some subsequent proceedings that could be contemplated to determine a remedy. I'm going to admit, Appellee's going to say that there's no right to a plea bargain, but the case law is clear. This is not an issue of the right to a plea bargain. It's a right to be informed about the plea bargaining process, which that was a statement of law from before Lafler and Missouri versus Fry. Clearly, that's more emphasized now. The only case that Florida's dealt with this is the Alcorn case, at least in any definitive way. The Alcorn case, they modified some earlier case law, and then this was also a case where they sent it back to the court for further consideration of what happened put the parties in the place they were before the trial, set aside the verdict, set aside the trial, and put the parties in the position where they were at the time the court made the mistake, or according to some of the case law, when the defense attorney made the mistake. Frankly, I don't believe that the trial court in that last quadrant, that last hemisphere, avoids responsibility in what happened here. Yes, there is some silence as to what happened, but the plea discussions that went on were after the judge made a misstatement of law regarding his sentencing discretion. It was clear, everybody knew PRR was on the table.
Sir, you're at 17 if you want to save a few minutes.
I was going to say I'll reserve my
Thank you.
final comments. Thank you.
May it please the court, Cerise Taylor on behalf of the state of Florida. The Kmart policy is not law. That's clear. The evidence that they were seeking to admit regarding issue 1 was evidence of the reason for the termination and evidence with regard to Kmart policy. The Kmart policy is irrelevant because the state had a burden to prove the robbery and how far away an individual was from the loss prevention officer when the loss prevention officer approached them isn't relevant to the issue of the robbery. The elements of the robbery were established by evidence from all of the witnesses that the individuals took the property, they exited the garden center entrance of the store, the loss prevention officer approached them, and that's when they took the cart and they shoved it toward him, and Mr. Murray went ahead and swung at him, and that's when further scuffling took place, and then it went out into the parking lot. So the state satisfied its burden, and with regard to the Kmart policy about when and where the loss prevention officer can approach someone was really irrelevant. The issue with regard to why he was fired really would only be relevant to the issue of bias. And the court is absolutely correct. This was not, there was no proffer, there was no evidence offered of the deposition, that, what actually occurred for the reasoning behind the firing. And when you look at the language the lawyers use, really it's speculative. They say, well, we think, and it's like 10 feet, and they don't even really have that evidence to make a proffer. But regardless, the issue of bias is really a non-issue because the testimony is consistent. With Peterson, the individual had a motive, and there was she was the only witness who could identify whether or not there was property on Mr. Peterson when he left the store. In this case, we have Mr. Brittingham, the one loss prevention officer, then we had another loss prevention officer, the store manager, and a helpful citizen, who all testified consistently with what happened outside the store. And so even if this bias evidence was somehow admissible, it would have been relevant because there was no question that he had a bias problem that would affect his testimony, the nature of his testimony. With regard to the second issue, what everyone knew, the substance of the plea negotiations, the advice of counsel, what Mr. Murray was thinking at the time, All of this is the very reason that claims like this are really post-conviction claims. This court has found that claims about alleged misadvice by the trial judge or misdirection by the trial judge are 3850 claims for this very reason, because we have to get to the heart of what everybody was thinking and what everybody knew. There is no right, obviously, to plea bargaining, and there is no established right to have a knowing, voluntary, and intelligent rejection of the plea. Rule 3.72 creates a burden on the trial court because when an individual is entering a plea, they're giving up a substantive right. And it is the trial court's responsibility to make sure that that right is given up knowingly, voluntarily, and intelligently. But since there is no right to a plea bargain, if the individual rejects the plea bargain and thinks in their best interests, I would rather see what my future holds, then there is no obligation in the trial court to make sure that you have any information beyond that you have a right to. Go ahead and proceed to trial, and if you reject the plea, that's fine. The trial court in this case was just trying to get everything on the table to prevent post-conviction challenges and to get everyone talking to each other. He didn't inject himself into the plea process. There is no evidence of an objection at the PRR stage. So it's obvious that Mr. Murray knew that he was PRR. And the state attorney actually says that the plea offer is a PRR offer. And so even if you were to go back and say, well, what would have happened otherwise? Once they got to, first of all, it's clear he did not want a 30-year plea, that he wanted the court, he wanted his lawyer to make the 4-year plea deal, and that's what ultimately happened. The court says, well, they're there, you're here, talk to them, and that's what the defendant does, and takes it upon himself to say, I want to know, did my lawyer make the 4-year plea deal? The court says, do you accept that? The state says no. And so really that is the end of the plea process. It's obvious going in that he wants to take his chances. Also, just going back to 3.72, the trial court's responsibility in discussing the plea colloquy is to make sure that the individual entering into a plea knows the potential maximum sentence for the crime that they are entering a plea to. And in this case, if it's a direct consequence, the trial court has an obligation to advise the defendant. This is not a direct consequence situation because there's still presumption of innocence. When he rejects the plea, he's presumed innocent and he has a right to trial, which he avails himself of. Once he is in trial, he could be acquitted. He could be convicted of a lesser charge. And so there is no direct consequence that results from this that would impose this due process obligation on the trial court. That being said, unless the court has any other questions, the state believes that this conviction and sentence were properly based on the evidence of the robbery and that there was no due process violation in conjunction with his rejection of the plea and that the sentence and the conviction should be affirmed. Thank you.
Thank you.
Just to be clear on the facts, the entire encounter occurred outside the store. And various witnesses saw various parts of it. The reason why this is not harmless error is, one, Mr. Brittingham is the main witness, he's the alleged victim. And two, he would be the one who would be able to say accurately, was this inside a boundary that I'm supposed to act or outside the boundary that I'm supposed to act?
What difference does it make if all the witnesses say the defendant took a swing at him and then ultimately pulled a knife after the co-defendant drove up and what appeared to be trying to run him over or something?
Well, I think
What
she
difference
threw
does that-
some soda on him or
What
something like
difference
that.
does that make other than to confuse and mislead the jury? Because the jury then has to say to themselves, well, if he violated company policy, maybe that's a defense.
The question is, and the jury is instructed, that the force, violence, assault, or putting in fear has to be in the course of the taking. And that was what the theory of the defense was, that they were separate acts. Obviously, state presented evidence, that supported. We're not raising a JOA issue. The issue is the limitation of the cross-examination of Mr. Brittingham to test him whether or not his account ought to have been believed regarding in the course of the taking. As it relates to the due process issue, we can't raise post-conviction the actions of the judge. Yes, and we've specifically reserved on post-conviction or regarding ineffective assistance of counsel, but we're here today This court is supposed to review the actions of the trial court below, and the trial judge, when he brings the subject up, has the duty to not mislead the defendant as to what his standing is in court. That's what happened in this case. It's the typical rush to get the trial started, but if the court had stayed away from the subject completely and not be so concerned about post-conviction issues, then we wouldn't be in this situation here today. We're asking the court to reverse on the limitation of cross-examination issue. We're also asking the court to consider that there was a due process violation and to either reduce it to a 30-year or to send it back to the trial court for further consideration. Thank you very much.
Thank you both. Our next case